The first landmark judgment is from Jammu and Kashmir and Ladakh, that is Jammu High Court. The facts of the case is the High Court restrained tax authority from taking coercive action under section. The question here is whether arbitral award is subject to GST. And this notice has been issued under section 73. In this, section 73 subsection 1 is a very important section. Hindustan Construction Company argued that the payment received is merely an interim order. The circular was not issued by the board but by the commissioner itself, who was holding that power. The blocking of the petitioner's electronic credit ledger. So we all know about electronic credit ledger. This observation by the Karnataka High Court is a landmark judgment because you cannot block the electronic credit ledger, arguing that these extended the time limit for adjudication of show cause notices. It is very, very important for the listeners to understand what is section 168A. GST Judicial Outlook for the day. This is an effort to bring various GST cases that happened over a week from across the high courts. The first of the GST case is from, that is GST Outlook number 1, GST landmark judgment. The first landmark judgment is from Jammu and Kashmir and Ladakh, that is Jammu High Court. My dear friends, this is a case with respect to Hindustan Construction Company Limited versus Union of India and others, WPC number 1466/2025. In this, Hindustan Construction Company challenges the GST demand on an arbitrary award, and J&K, that is Jammu and Kashmir High Court, grants interim protection. The facts of the case is the High Court restrained tax authority from taking coercive action under section 73 of the CGST Act against Hindustan Corporation Company Limited, that is HEC Limited, providing an interim relief while the legality of the GST demand is under judicial review. My dear friends, the case revolves around a GST demand raised on an amount received by HEC pursuant to an arbitral award. The question here is whether arbitral award is subject to GST. And this notice has been issued under section 73. For the benefit of all the listeners, we have to understand what is section 73 all about. Section 73 of the CGST Act 2017 provides for determination of tax pertaining to the period up to financial year 2023-24 not paid or short paid or erroneously refunded or input tax credit wrongly availed or utilized for any reason other than fraud or any willful misstatement or suppression of facts. In this, section 73 subsection 1 is a very important section. For the benefit of the listeners, I will quote the exact words of the Act, where it appears to the proper officer that any tax has not been paid or short paid or erroneously refunded, or where input tax credit has been wrongly availed or utilized for any reason other than the reason of fraud or any willful misstatement or suppression of facts to evade tax, he shall serve notice on the person chargeable with tax which has not been paid, which has not been so paid, or which has been short paid, or whom the refund has erroneously been made, or who has wrongly availed or utilized input tax credit, requiring him to show cause as to why he should not pay the amount specified in the notice along with interest payable thereon under section 50 and a penalty leviable under the provisions of this Act or the rules made thereunder. Accordingly, my dear friends, the department issued notice, that is CGST department issued notice to HEC, under which the demand was raised under section 73. The submission of the petitioner, that is HEC, is that Hindustan Construction Company argued that the payment received is merely an interim order, interim deposit subject to the final outcome of the ongoing litigation. So the litigation is ongoing. Accordingly, the arbitral award is only an interim protection. So, my dear friends, accordingly, thus it is not liable to GST is the argument of HEC. And it also said in its petition, that is the petitioner clearly said, it does not constitute a concluded or enforceable consideration as the litigation is ongoing. It is also emphasized that the deposited amount is secured by immovable property. So reinforcing its provisional nature and further questioning the applicability of GST on such conditional transaction. So the two important point to be remembered is, even though it is an arbitral award, it is only a provisional nature because litigation is ongoing, and beyond that, the further questioning on the applicability of the GST on such conditional transaction, whether GST can be applied, is a question. Accordingly, the petitioner contended that the GST order contravenes Rule 26 Clause 3 of the CGST Rules 2017, which deals with the authentication of documents, hinting at procedural lapses in issuing a demand notice. My dear friends, this is one of the landmark judgment concerning arbitral award, that too when the litigation is ongoing. GST landmark judgment number 2. My dear friends, this is a landmark judgment from Rajasthan High Court concerning Mohit Kirana Store versus Central Board of Indirect Taxes and Customs and others, civil writ petition number 1030 of 2022. My dear friends, in this, Rajasthan High Court to examine validity of circular empowering superintendent to issue summons grants absolute stay. The question here is before the Rajasthan High Court whether superintendent of GST can issue summons. My dear friends, the facts of the case is the petitioner contested the validity of CBIC's circular number 3/2017, arguing that it unlawfully delegated the power to issue summons under the GST Act to superintendents, whereas such authority lies exclusively with the commissioner as per section 2 subsection 91 of the CGST Act 2017. My dear friends, the petitioner emphasized the legal distinction between powers granted to commissioner in the board and those held by the board itself. So the differentiation is there are two types of power provided: power granted to commissioner in the board and the board having the power itself, asserting that board lacked authority to delegate such quasi-judicial powers through a circular. So ideally, powers cannot be delegated through a circular. So the petitioner contended that circular cannot delegate the power conferred on the commissioner or the board. The revenue countered the petitioner's argument. So revenue went on to counter the petitioner's argument, stating that the circular was not issued by the board but by the commissioner. So the revenue said the circular was not issued by the board but by the commissioner itself who was holding that power, thereby suggesting that the delegation was within the bounds of statutory authority. Meanwhile, the Rajasthan High Court acknowledged a strong prima facie case in favor of the petitioner and confirmed its earlier interim stay on circular's operation, making the stay order absolute pending final adjudication. Absolute pending final adjudication. My dear friends, recognizing the legal significance and wide impact of the issue, the High Court scheduled the case for final hearing in the upcoming weeks shortly, indicating a priority review of the challenge to the circular legality. My dear friends, the summary of this issue, whether the power can be delegated through a circular by the commissioner himself or the board. The question here is whether it can be delegated or not will be decided in the days to come. However, Rajasthan High Court has provided stay over this circular. GST landmark judgment number 3. My dear friends, this judgment pertains to Allahabad High Court in case of DR Hotels Private Limited versus Deputy Commissioner Section 20 State GST Lucknow, writ tax number 575 of 2025. Under that, the High Court, it was held, the Allahabad High Court has held deeming service through email, mobile number, a proper service relegates assessee to file appeal. My dear friends, the facts of the case is the court upheld the service of notice under section 169 of the CGST Act is valid when sent through the email and mobile number provided by the assessee at the time of registration, emphasizing the acceptability of electronic communication as a legitimate mode of service. My dear friends, by invoking section 13 of Information Technology Act 2000, the court reinforced that electronic records sent to the declared email, mobile or deemed properly dispatched and received thus satisfying legal service requirement under the CGST framework. My dear friends, the court clarified that section 169 gives assessing officer discretion in choosing the mode of service. He can serve through email, courier or speed post, making it unnecessary for the assessee to be served in person or only via physical means. So there was no requirement, is the contention of the revenue, that it need to be served physically. The High Court ruled that there is no breach of fundamental rights of the assessee due to the service mode used, as a due process under section 169 clause C was followed, ensuring procedural fairness during and after assessment. My dear friends, High Court has emphasized the principle of alternate efficacy remedy. The court held that the assessee should pursue an appeal under section 107 of the CGST Act, thereby dismissing the writ petition as non-maintainable. GST landmark judgment number 4. My dear friends, this is the landmark judgment issued by Guwahati High Court. It is with respect to Hometoken 2017 versus State of Assam and others, WP number 2918/2025. It was held by the High Court that tax determination merely supplementary to full SCN cannot override proper and authenticated documents mandate. My dear friends, the facts of the cases: summaries issued in GST forms DRC 01, DRC 02, DRC 07 are supplementary documents and cannot replace or override legal necessity of issuing a proper authenticated primary SCN as mandated under section 73 of the CGST Act 2017. My dear friends, demand orders based solely on unsigned summary SCNs, very important, unsigned summary show cause notices, including tax determination, attachments uploaded in DRC 01 and DRC 07 without proper authentication by a proper officer are invalid is all time we have to understand. It is invalid and violate Rule 26 Sub Rule 3 and Section 73 procedural safeguards. My dear friends, the High Court took it very seriously and reaffirmed that the issuance of valid show cause notice, a statement under Section 73 subsection 3 and an opportunity of hearing under Section 75 subsection 4 are mandatory preconditions before issuing any demand order, citing precedent from Jharkhand and Karnataka High Courts. My dear friends, the court noted that Rule 26 Sub Rule 3, which governs authentication of notices under Chapter 3, registration, does not explicitly apply to Chapter 18, demand and recovery, exposing a regulatory gap. Nevertheless, proper authentication remains essential for validity. Due to non-compliance with authentication and hearing requirements, incomplete DRC 01 details, the High Court quashed the impugned demand orders, allowed the department to initiate fresh proceedings in compliance with legal mandates. It was held in Guwahati High Court judgment, Hometoken 2017 versus State of Assam and others. GST landmark judgment number 5 is with respect to Karnataka High Court. It was Karnataka High Court, SA Industries versus Assistant Commissioner of Central Tax, writ petition number 5820 of 2025. My dear friends, it was held that ordered to be quashed as electronic credit ledger was blocked without pre-decisional hearing and based on borrowed satisfaction. It was held by the High Court. The case here, the facts of the case here is the case concerns the blocking of the petitioner's electronic credit ledger. So we all know about electronic credit ledger. It is blocked, effectively denying input tax credit without proper procedural safeguards. Accordingly, my dear friends, the petitioner was not afforded a pre-decisional hearing. So there was no hearing at all. Principles of natural justice was not followed before the impugned order was passed, violating principles of natural justice. The point here is the order blocking the credit ledger was limited to a brief text message without detailed reasoning or independent evaluation. My dear friends, the order depended solely on reports from enforcement authority without independent verification or cogent reasons, which is impermissible under law. My dear friends, due to procedural and substantive deficiencies, the order was quashed. The petitioner's electronic credit ledger was ordered to be unblocked. Accordingly, my dear friends, this observation by the Karnataka High Court is a landmark judgment because you cannot block the electronic credit ledger without applying the procedural safeguards provided under the CGST law. If so, then it might become unconstitutional, unlawful. GST landmark judgment number 6. My dear friends, this is with respect to Bombay High Court judgment. It was held in Tushar Builders and BKP Infra Private Limited versus Deputy Commissioner of State Tax Pune. Writ petition number 5610 of 2025. It was held that execution of order stayed as assessee contested validity of notification extending adjudication period. My dear friends, the assessee in this case contested the validity of notification number 56/2023, Central Tax 28 December 2023 and notification number 56/2023, State Tax 16/1/2024, arguing that these extended the time limit for adjudication of show cause notices without proper legal authority under section 168A of the CGST Act, which requires recommendation from the GST Council. The lack of such recommendation rendered the notification void ab initio. It is very, very important for the listeners to understand what is section 168A. My dear friends, section 168A is the power of government to extend time limit in special circumstances. In this, it was held, section 168A subsection 1, notwithstanding anything contained in this act, the government may, on the recommendation of the council, very, very important, government may, on the recommendation of the council, by notification, extend the time limit specified in, as prescribed or notified under this act in respect of actions which cannot be completed or complied with due to force majeure. My dear friends, section 168A subsection 2 provides for the power to issue notifications under section subsection 1 shall include the power to give retrospective effect to such notifications from the date not earlier than the date of commencement of this act. The explanation provided under this section is, for the purpose of this section, the expression force majeure means a cease of war, epidemic, flood, drought, fire, cyclone, earthquake, or any other calamity caused by nature or otherwise affecting the implementation of any of the provisions of this act. According, my dear friends, as you understand section 168A, it is a requirement to have recommendation from the GST Council. Accordingly, assessee contended that if these notifications are quashed, the impugned order in original, OIO, impugned order in original would fall outside the permissible time frame under section 73 subsection 10 of the CGST Act, which prescribes a 3-year limitation from the relevant due date. My dear friends, thus the OIO, that is order in original, would be barred by limitation and invalid. It was also argued that section 73 subsection 1, the show cause notice must be issued at least 3 months prior to the expiry of the limitation under section 73 subsection 10. Since the show cause notice was issued on 31/5/2024, the exact last date under limitation, it violated the mandatory 3-month lead time requirement, further invalidating the proceedings. My dear friends, the court took note of the similar factual situation in Sandguard Builders LLP versus Union of India, where the issuance of show cause notice and adjudication beyond the limitation period due to flawed notification was challenged. The court found parity and accepted the basis for interim relief. My dear friends, given the legal issues, especially regarding the invalidity of notifications and breach of mandatory timelines, the court granted ad interim relief, staying the effect, operation and execution of impugned order in original, that is OIO, until further orders, thus protecting the assessee from coercive recovery. GST landmark judgment number 7. My dear friends, this is with respect to Orissa High Court judgment concerning Debdish Mohapatra versus State Tax Officer CT and GST WP number 16344 of 2025. My dear friends, it was held delay in revocation application condoned as assessee showed readiness to pay tax, interest, late fee and penalty. It was held in the High Court. My dear friends, the facts of the case is the assessee's GST registration was cancelled and there was a delay in filing the application for revocation under Rule 23 of the Orissa GST rules. The assessee demonstrated readiness to comply. Assessee in this case demonstrated readiness to comply with all statutory obligations, including payment of tax, interest, late fee, penalties for the return filing to be accepted by the department. Accordingly, my dear friends, the decision referenced the coordinate bench ruling in Mrs. Mohanty Enterprises vs. Commissioner CT and GST Odisha 2022, which supported the continuation of delay in revocation application under similar circumstances. My dear friends, the court held that proviso to Rule 23 of the Orissa GST rules allows for flexibility in condoning delay, particularly when the assessee shows bona fide intent and readiness to regularize compliance. My dear friends, the court directed that subject to payment of all dues and compliance with procedural requirements, the assessee's revocation application should be considered on merits in accordance with law. My dear friends, this is the landmark judgment wherein certain times the continuation of the delay also is done with respect to revocation of cancellation, considering the fact that it could support the revenue as well. Concerning this matter, Orissa High Court judgment is definitely a landmark judgment with respect to revocation of cancellation of registration of GST. Thank you. Signing off, Advocate Dr. M. Sathya Kumar.